in Europe. He was captured, he found his way after the war using false identities to Argentina, and he was captured there in 1960 by Israeli Mossad agents. He was indicted by an Israeli court under a 1950 law for crimes against the Jewish people, which, frankly, if you look at the elements, is largely akin to genocide, crimes against humanity, and war crimes. And the Jerusalem District Court upheld Israel's jurisdiction to try Eichmann. This, by the way, was affirmed by the Israeli Supreme Court, and I quote, "The abhorrent crimes defined in this law are not crimes under Israeli law alone. These crimes, which struck at the whole of mankind and shocked the conscience of nations, are grave offenses against the law of nations itself. Therefore, so far from international law negating or limiting the jurisdiction of countries with respect to such crimes, international law is in need of the judicial and legislative organs of every country to give effect to its criminal interdictions and to bring the criminals to trial. The jurisdiction to try crimes under international law is universal." Another watershed moment in the development of universal jurisdiction came not that long ago, about 10 years ago, the Augusto Pinochet case, which had its drama unfolding right here in the UK. Pinochet came to power in a violent coup in 1973, overthrowing Salvador Allende and establishing a dictatorship that was responsible over the next 17 years for the disappearance, torture, and murder of thousands of political opponents. In October 1998, while visiting here for medical treatment, he was arrested on Spanish provisional warrants, charging him with various human rights crimes. And then after a hard-fought 16-month legal battle, which most of us probably remember being reported on quite a bit in the papers, the House of Lords ruled that certain jus cogens crimes, such as torture, were not protected by former head of state immunity, and that in the case of Pinochet, extradition could proceed. And in this case, of course, Pinochet was subject of this warrant that was issued by Judge Garzón in Spain, and therefore they ruled that the extradition could go forward. Despite the fact that Pinochet was eventually released and not extradited to Spain due to his supposed ill health, this vindication of universal jurisdiction, as I mentioned, is really a watershed event in international law, with some scholars considering it one of the most important events in judicial history since the Nuremberg trials of Nazi war criminals. Now, this sets the stage for us to talk about the various laws that domestic jurisdictions enact so that they can assert universal jurisdiction. It is not a one-size-fits-all proposition. There are different variations of universal jurisdiction. There is the more narrow variety, which we see in the United States. As a matter of fact, the United States had an extremely narrow version of universal jurisdiction. Its genocide statute, which enacted its obligation under the Genocide Convention, for example, until recently, only permitted jurisdiction over U.S. citizens or when the crime of genocide was committed on U.S. soil. That has since been expanded and is now truly universal with the Genocide Accountability Act of 2007. We also recently, just this year, enacted the Child Soldier Accountability Act. But we are still narrow. It's only in these narrow versions, it's only the state where the accused is found in and is in custody that the jurisdiction can prosecute. This is known as the forum de prehensionis. In certain states, there must be a link between the forum state and the nationality of the perpetrator or the victim. This is another, as I say, narrowing factor. And then only the state can initiate prosecutions. And in a moment, you may think, well, of course only the state can initiate prosecutions, but no, hold on, because there are jurisdictions where that is not the case. And we see this in the broader versions. Spain, its current law is like that. Belgium's old law that was mentioned earlier by Ambassador Gold in connection with the prosecution of Ariel Sharon. The accused may be prosecuted in these jurisdictions regardless of whether the person is present in the forum state. There is no connection necessary with the territory, the perpetrator, or the victim. And proceedings may be brought by private parties. They can file complaints that initiate the action. It is not the state that is the sole determiner of whether or not the case will go forward. Now, notwithstanding the abuses that we're here to talk about, there have been positive developments with respect to universal jurisdiction. Now, Spain, I mentioned a moment ago, since 1999 has indicted and in one instance convicted Adolfo Eichmann is the one who was convicted, a number of ex-members of military juntas from Latin America who might have otherwise gone unpunished. You see here a photo of Eichmann. Rwandan and Yugoslav mass murderers have been prosecuted in various jurisdictions such as Germany, Switzerland, Belgium, and currently in Canada, where Desiree Munyaneza is now being prosecuted. It's in trial. This helps arguably ease the international community's resources burden and sends the message that these countries will not provide a safe haven for atrocity perpetrators. Universal jurisdiction has also assisted the ICTY and the ICTR in implementing their respective completion strategies by transferring cases to jurisdictions such as the Netherlands, and that's done through universal jurisdiction laws. This is permitting the ad hoc tribunals to wind down and wrap up. The other thing I would point out is that there are cases of other infamous dictators. Hissène Habré, for example, formerly the dictator in Chad, who is currently in Senegal, has been the subject of universal jurisdiction proceedings, and Belgium initiated those. So we can see that dictators like that, possibly somebody like Mengistu from Ethiopia, is another one we could imagine where universal jurisdiction might be helpful in terms of closing the impunity gap. However, we all know that there have been some troubling developments with respect to universal jurisdiction. We heard about General Amon's ordeal, and we know that universal jurisdiction has in fact been used to settle political scores. It's been used as a political vendetta. It has been used to gain political leverage, and that is not acceptable. The 1993 Belgian law, which I alluded to a moment ago, was used to indict everybody from not just Donald Rumsfeld, who might be a little more controversial, even Colin Powell, to Fidel Castro, to Ariel Sharon. I mean, there were just a long list of defendants in these cases that it looked extremely political. I would point out that universal jurisdiction can be extremely expensive given the lack of linkage between the forum state and the crime and victims and perpetrators. Time-consuming and inefficient. The Munyaneza trial that I just mentioned a moment ago is still going on. It is now nearly in its second year. It's nearly finished its second year of trial. It's cost millions of Canadian dollars. 13 witnesses, for example, were flown in from Rwanda, and the trial actually moved from Canada to France to Rwanda and Tanzania, and it's taken years. So it can be problematic in that regard. And then there is a lack of uniformity in the way that the universal jurisdiction laws are formulated in procedure and in punishment, and that lack of uniformity can be troubling. I want to mention now a case study, something that is hot off the press as we speak, this situation between France and Rwanda. Many of you may be aware of the fact that France has been implicated in the 1994 Rwandan genocide, where they helped arm extremist Hutus and help them escape after the genocide through what is known as Opération Turquoise. France has clearly had very hostile relations with the rebel group that took over in Rwanda, the RPF, the Rwandan Patriotic Front, since the early 1990s, when the RPF was frankly trying to invade from Uganda. and France was supporting the Hutu government at the time. And there was a sense that, and it's interesting here being in the UK, because there was a sense, I think, from France that there was an invasion on Francophonie by these Ugandan rebels who were coming from a former English colony, and they were trying to attack the French power base in Africa. How dare they? And there was a sense that France needed to support the Hutu government because it was Francophone. And so to a certain extent, many people see the linguistic nature of the Rwandan genocide. It's unimaginable. It's unimaginable that all these people were slaughtered to a certain extent because of this issue. In the meantime, a number of genocidaires took refuge in France. Wenceslas Munichaka, who was a priest who committed crimes in the Saint Famille church in Kigali, Laurent Bucci-Baruta, Clave Kamana, Marcel Bivugavagado, and Isaac Kamali, all subject of international arrest warrants. They are in France. And France is not using universal jurisdiction, as it could, to prosecute these people. It is harboring genocidaires. Yet, at the same time, in 2006, a French judge issued arrest warrants for 9 Rwandan officials, including President Paul Kagame, linking them to the killing of Rwanda's former president, Juvenal Habyarimana, whose plane was shot down in 1994, and which is the thing that triggered the genocide in Rwanda in 1994. And with respect to these indictments, I'm quoting from an op-ed piece from the Los Angeles Times. Quote, "It was an odd indictment by international standards. The judge did not consider alternative theories, did not visit Rwanda, and did not conduct any investigation of his own. Yet it served the French goal of painting Kagame's government as a gang of criminals." Part 4. Rwanda then broke off diplomatic relations with France after the indictments, and then established its own commission to investigate France's role in the genocide, upping the ante and the diplomatic crisis. And after months of hearings, that commission concluded that France's support for the genocide was of a political, military, diplomatic, and logistic nature, and named high-ranking French officials who should be brought before international tribunals according to the commission. They include prominent military commanders and prominent politicians, including former Prime Ministers Edouard Balladur, Dominique de Villepin, and former Foreign Ministers Alain Juppé and Hubert Védrine. So some very high-ranking, very prestigious French politicians. Rwanda has officially applied, in the meantime, to join the British Commonwealth, and last month Kagame announced that English would replace French as Rwanda's official second language. So the ultimate crime, as far as France is concerned, is now being committed. This was the logic of where this was all going when these Ugandan rebels attacked in 1990. So what happens? Our final part 5. On November 9th, 2008, after this horrible decision by Kagame's government, Rose Kabuye, chief of protocol for Rwandan President Paul Kagame, and one of the 9 who was indicted, was arrested in Frankfurt, Germany, on an international arrest warrant issued in France. She was then transferred to France on November 19th. So this is all extremely recent. This, I think, frankly, along with the failure to prosecute notorious genocidaires, the ones I mentioned a moment ago, such as Munichaka, represents universal jurisdiction being abused by France to gain political leverage in its high-stakes diplomatic battle against Rwanda. I think this is a very clear case of one of those abuses of universal jurisdiction. And in fact, earlier this year, the African Union called for a moratorium on indictments against Rwandan officials, which it condemned as politically motivated. So, this is quite an ugly situation that we have here, despite the good intentions of universal jurisdiction and the positive effects that it has had. So, is there a solution to this problem? I think there might be. I propose that there should be a treaty on universal jurisdiction. And I recommend as a starting point that such a treaty incorporate what are known as the Princeton Principles on Universal Jurisdiction from 2001. And I'm just going to give you the highlights of the Princeton Principles that I think should be the basic foundation for this treaty. First of all, that crimes subject to universal jurisdiction include piracy, slavery, war crimes, crimes against peace, crimes against humanity, genocide, and torture. That's from principle number 2. The application of universal jurisdiction to the crimes listed above is without prejudice to the application of universal jurisdiction to other crimes under international law, also from principle 2, and which also recognizes that jus cogens is an evolving phenomenon. And so there could be other crimes which we could imagine should be subject to universal jurisdiction. Another important point, once out of office, government officials, including heads of state, should not be immune from prosecution based on the defense that they were acting in an official capacity. That's principle 5. There should be no statute of limitations on the prosecution of these crimes, principle 6. And blanket amnesties generally are inconsistent with a nation's obligation to hold individuals accountable for these crimes. That's principle 7. So these are the, if you will, the positive aspects of what would be part of a treaty. Now, there are also protective aspects that we can find in the Princeton Principles, and I want to talk about those for a moment. A state shall exercise universal jurisdiction in good faith, and in accordance with its rights and obligations under international law. That's from principle 1. In exercising universal jurisdiction, a state and its judicial organs shall observe international due process norms, including, but not limited to, those involving the rights of the accused and victims, the fairness of the proceedings, and the independence and impartiality of the judiciary. That's also from principle 1. You can see that 2 of these protected principles are in principle 1, the very first principle of the document. In the exercise of universal jurisdiction, a state or its judicial organs shall ensure that a person who is subject to criminal proceedings shall not be exposed to multiple prosecutions or punishment for the same criminal conduct. This links to the notion of ne bis in idem, which we talked about earlier when we talked about the papers, if we will, from the United States, double jeopardy. And then finally, a state shall refuse to entertain a request for extradition based on universal jurisdiction if the person sought is likely to face a death penalty sentence or to be subjected to torture or any other cruel, degrading, or inhuman punishment or treatment, or if it is likely that the person sought will be subjected to sham proceedings in which international due process norms will be violated. That's from principle 10. Okay, so this is what we can take, I posit, from the Princeton Principles. I believe, however, that there are additional safeguards that we need to incorporate for this treaty to be successful. My first proposed additional protection deals with a concept that's difficult to define, but I put it in there anyway. We have to have aspirations, and this is one of the aspirations that I feel I need to talk about, even though I can't precisely define it. Apolitical prosecutions. Foreign states should only take cases where justice, as opposed to political leverage, is determined to be the sole reason for the process. And maybe it's a little bit like Justice Blackmun from the U.S. Supreme Court trying to define pornography. Maybe it's impossible to have a specific definition, but we know it when we see it. And when we just looked at the situation between France and Rwanda, we know we see political prosecution. That should not be kosher. There should be special scrutiny of claims perceived to be taking sides in connection with an ongoing conflict, primarily of a political nature. So I believe that any such treaty should have a strict scrutiny provision within it related to anything that seems to be political. And again, although no precise guideline is possible, some consideration should be given to the cost of trials to public order. Public order outweighing their benefits to combating impunity. That there should be some kind of cost-benefit analysis that is conducted. Additional protection number 2. Decisions to prosecute should be made by criminal justice system officials, not private citizens. Although private citizens should have access to prosecutors to raise potential claims and provide supporting evidence, the state alone should make the decision to prosecute. Secondly, this should entail the prosecutor's obligation to seek authorization to investigate and prosecute from a pretrial magistrate, which is akin to the proceeding that currently exists in the International Criminal Court. I think that kind of protective principle ought to be in place in any kind of universal jurisdiction treaty that countries would enter into. Number 3, the presence of the accused. Remember I talked about the narrow versus the broad version of universal jurisdiction. This is one of the key distinguishing points. I believe the accused should be present in the forum state for a prosecution to go forward. I have here the case of the Rwandan nuns who in 2001 were convicted of genocide in connection with their acts in 1994 related to parishioners who were trapped in their church. I would contend that universal jurisdiction cases function best where the accused is already in the country, the nuns being an example, in a criminal court. And according to complementarity, a domestic jurisdiction should take the first crack at prosecuting a case, not an international court, in this case not a universal jurisdiction prosecution. The jurisdiction that has territorial claims to the case, that has links between the victims and or the perpetrators, those are the ones that should take the case first. They should have the first crack. And then at the same time, the forum state should have an independent, fair, and effective judiciary. I would conclude by saying that the debate and the debates regarding universal jurisdiction implicate some pretty compelling dilemmas. Idealism versus pragmatism, law versus power, community-minded state versus hegemony, human rights versus foreign policy imperatives, international justice versus impunity. These are not difficult ones to resolve, but I think we need to strike the right balance to end the culture of impunity, and I think that universal jurisdiction can serve an important function in being a gap filler in that regard. While at the same time, we have to establish safeguards against the potential abuse of your universal jurisdiction. So thank you for your time and consideration.
Thank you, Professor Gordon. Our next speaker, this is a perfect link to Professor Gordon's speech, especially in light of his point 6. We have the privilege of having with us Irit Khan from Israel, who was the head of the international legal section of the Israeli Justice Ministry and has dealt with cases of universal jurisdiction as a representing the state of Israel, from the efforts of the Belgians to try former Prime Minister Ariel Sharon and to other cases as well. What we were speaking about earlier, what I think Professor Gordon was speaking about, was this notion of complementarity. What if the state in question, the citizen is being sought under a universal jurisdiction, has an advanced legal system, and in fact goes after people who engage in war crimes or violate the laws of war? Should that be a different situation than a state in which war criminals thrive and court systems are sort of chaotic and don't really protect international law? These are some of the issues I'm sure Irit Khan will deal with, and I turn the floor over to her.
May I respect the moment? Questions will be taken if they can be written down and brought to the corner of this table, and at the end they will be taken, but they must be written.
Well, good afternoon. As I heard the lecture of Professor Gordon, I've changed my lecture completely, but I did not. And what came into my mind is that we should do 2 or 3 days a conference about your suggestion. Maybe in the days when my great-grandchildren will come to it, but after having the experience in Belgium, I have a lot of doubts. Because English is not my mother tongue and I have only 10 minutes and I want to cover all the subjects that I wrote it, so, and I'm reading it, so excuse me because usually I don't read my lectures. The concept of universal jurisdiction is controversial in the international legal world and not only in the legal world. I will try to bring to this panel my experience as head of the legal team defending Prime Minister Sharon in Belgium 2001, and I usually call it defending the state of Israel and not defending the Prime Minister Sharon. This was one of the first cases involving universal jurisdiction, and it was widely covered by the press and professional literature. As former head of the Department of the International Affairs of the Israeli Ministry of Justice, I have been involved in not a few situations concerning the military. In this situation on which I was consulted, which concerned military actions, we acted primarily according to the rule of international law, after extended deliberations. There is no doubt that there is a consensus that those who committed heinous crimes should stand trial and be subject to punishment. In carrying out this reaction to a miscarriage of justice via universal jurisdiction, the question is how to utilize the universal jurisdiction. And today I heard the first suggestion. I must say that until today I did not. When discussing the ICC, International Criminal Court, or judicial tribunals, the rules are clear. There are the rules of evidence, procedure, defense, and definition of offenses, implementation of international law. However, in exercise of universal jurisdiction, by various states, the problems begin. First, starting in the early 1990s, universal jurisdiction spread rapidly without comprehensive public debate. The result of which people stand trial in a country that has no nexus to the suspect, we talked about it, victim or place of the crime, before judges that have no international law experience. Such judges may not reach a proper decision. Universal jurisdiction is activated when the country in which the crime is committed does not or cannot prosecute. This is the way that we talk about it and the ICC talk about it. Therefore, it is conceivable that there might be difficulty in obtaining evidence from said country that has its own reason for not prosecuting. Let's take the case of Sharon. Let's say that in the end of the day, Belgium would decide to indict Sharon. Now, they would need evidence from Israel, because if we are talking about Sabra and Shatila, the two Lebanese villages, and what had happened with the Israeli army, probably a legal assistance request will come to Israel in order to submit material and evidence to Belgium. No way that Israel would answer, because Israel said that it was, you know, that we took even our ambassador from Belgium at a certain stage when the Court of Cassation in Belgium decided that there was a place to indict Sharon. So this is a big problem, because if some country is deciding to try a person when the other country is not agreeing, then where the evidence coming from? This is a very, very big problem. And we can take today example as Sudan. Because Sudan is not cooperating with the ICC, and for sure won't give evidence. So here I'm talking about the ICC, which is a court that there was a consensus and a treaty. But if we're talking about two countries, this problem is a really big problem. Now, the entrance of politics to the universal jurisdiction process may be found in the many actions brought by NGOs that are supported financially by special interest groups or even states for the benefit of their own agendas. I'm not saying that all the NGOs are like this. NGOs are doing fantastic work. But there is a big group of NGOs, especially that are founded by Palestinians, if we're talking in the case of Israel, that they have their own agenda. In this way, the states offering universal jurisdiction are utilized in opposition to the goals for which they adopted universal jurisdiction laws. We should also consider the delicate balance between state and the political relationships. It is interesting to note how some African nations view universal jurisdiction. Recently, and I'm not going into the case that Professor Gordon wrote, what we have to say, I think that we didn't say that this lady was on a mission from Rwanda, and she was arrested in Germany, by the way, in order to extradite her to France. And Rwanda took as I remember, their ambassador from Germany at that time. And this is an example of why some African nations refer to universal jurisdiction as Western judicial imperialism. That's what was written right now. because they do not see cases brought by the Western nations against another Western nation. Could you envision a European state bringing action against US general and politicians for war crimes in Iraq? Well, Belgium considered it, but was deterred by the US threat to remove the NATO headquarters from Brussels. And here it ended. And it ended with the Sharon too. It was together. Universal jurisdiction is applied and also the ICC when a country does not, as I said it before, or cannot act to prosecute. To my regret, as Israeli army officers are subject to universal jurisdiction in different countries, not only in London or in England, one must question whether Israel is included in the category of states that would not or cannot take action against subject crimes. The answer, in my view, is clear. Israel is a democracy with a well-developed judicial system, as the following statistic prove, and I will give you now a bit of statistic, but before it I would like to say that the military judicial system is separate from the civilian courts with the ability to appeal decisions handed down in the lower courts. The Israeli Supreme Court, sitting in the High Court of Justice, receives complaints against the military courts and against the discretion of the military prosecution. It just happened a week ago. From the army, before I came here, it was interesting for me to know how many investigation and conviction happened in Israel, and I asked the military prosecution, who still remembers me from my former job, and he gave it to me. And I just would like to show you a very interesting data. Now, the second intifada in Israel was in 2000. So between 2000 and 2007, there were 272 investigations by the military police for illegal firing of weapons, 31 indictments, and 17 convictions follows. For property damage, 330 investigations, 36 indictments, 36 convictions. For violence, 475 investigations, 37 indictments, 34 convictions. For crimes in the Palestinian areas, 128 investigations, 20 indictments, 18 convictions. One must ask, when you hear such big numbers and then you come to conviction or to indictment and they are like a shrink or shrunk, not all of them are coming to the end of the day as convictions. But you have to understand that many times complaints are being submitted out of revenge or something like this. So we really have to find out exactly what was happening there. And this is the end. I'm not saying that everything is kosher, everything is really great. There are mistakes. Someone who doesn't work, will be very happy if we wouldn't have this very complicated situation. But the idea is that the soldier should know that if he's doing something wrong, and we know about it, and you know that today people have a cellular phone, and they take pictures, which I think that are very good, because we get the knowledge about those things. This is not the target of the Israeli army. The Israeli army was always, I was an officer in the army many years ago, we were always educated that we are a defense army, and we are acting according to values. And the day that we won't act according to values, we are going to lose the war. This was the education that I got, and my daughter was officer in the army got too. And as far as I know, we are doing it today. To tell you that there are not bad things, we just show, I think that it was shown all over television all over the world, by the way, when something like this happens, that some soldier, I don't want to torture, but humiliated a prisoner, and it was immediately came to the army, and all the human rights organizations in Israel are waiting to see the decision. So it's not that it's a closed army, a closed state, that we're not going to do those things. It's very, very important, and we really and I came there, so some of our military from the Air Force came there and said, what Irit is doing here? So the soldier said, we're not going without a lawyer. Because it became already a joke, we have to be with a lawyer. We don't know, can we do these things? We cannot do these things. And this is the situation that is happening there. So what I wanted to tell you, and I say it in short because I'm looking at Dore, he looks at his watch, that it's 2008, 9 months, from January to September, okay? There were much more complaints than I gave you before. The question is why? What happened in 2008? So, first of all, there was no open to this thing. We have women who are standing in the barriers, you know, and they try to calm the soldiers when people are moving there, but when they see that something happens, they come to the army and they report about it. Especially, in addition to this, there was a special committee in 1907 that was established in the army in order to take care of things that happen in the Palestinian territory. So we think that with the opening, with the globalization, with human rights, movements, etc., there is no an open way, or the soldiers feel even that they can complain when they think that something bad has happened, that someone decided to do something that is wrong. And there are wrong things, but we try as much as we can to prevent them. I'm just jumping. As I told you, the NGOs, Israeli NGOs that are really standing and looking at everything that they know about will come to trial, or to investigation, etc. And I can't and I don't have time to go into the Sharon case in Belgium, but telling you honestly, there was a big debate in the Ministry of Justice whether to defend Sharon in Belgium. There was an approach to say, who is Belgium? I got letters when I headed the team that said, Belgium, what did Belgium did in Congo? How can they be the judges of Sharon? And what is happening? Why should we defend Sharon? I was very much for to go to Belgium and to defend Sharon, because otherwise he could have become a prisoner of Zion. Because in a case that they would take out an arrest warrant between the European countries, there was a big danger that Sharon would come and, and someone would, at that time there was not yet the decision of Congo versus Belgium that spoke about the immunity, so we didn't know exactly what would happen. Afterward it was differently. And we decided that we have to defend it and to show what happened. Now, taking into account that in Belgium there were complaints, as we say in Hebrew, against the whole world and his wife. When we want to say in Hebrew something that there were so many, we said there were so many complaints about Gaddafi and Arafat and whoever. And they had to choose someone to start the thing with. What they took Sharon, and this was immediately in my mind a political thing. Why? Because if we talk about Sabra and Shatila in 1982, Israel was at war in Lebanon, and there were rumors about Sabra and Shatila, what happened there. And 400,000 people, including me, went to demonstrate and to ask the government to make an investigating committee to know what happened there. And as a result, we had an investigating committee, and that was composed from 2 Supreme Court judges. The name of the committee was the Committee Khan Committee, not on my name Khan, I was not there, and another high officer. And the end result was that Sharon was moved from his position as a Minister of Defense because of the claim of closing an eye. You should have known that the Phalangists are they have such a terrible relations against the Muslims, and you should have foreseen that something like this can happen. But I can tell you and assure you, there was not one Israeli soldier in Sabra and Shatila. And at the night before the court procedures had to be in Belgium, they used to play, every time that we were in Belgium, the Sabra and Shatila movie, in order to influence, the public opinion, etc. And in Italy they did it too, and there was a Palestinian girl who was sitting there and said, I was in Sabra and Shatila, and I saw the Israeli soldiers in the camps. So the guys that interviewed her asked her, how do you know that there were Israeli soldiers? She said, what do you mean? They had helmets with Magen David, the sign, the Jewish sign. No helmets in the Israeli army as Magen David. And the lies that were flying was unbelievable. So if you're asking yourself that after, in the war, investigating committee, big demonstration, 2 Supreme Court judges, this is a time to start when you have Gaddafi and all the others are in Belgium? is the answer? What would it be? This is the first thing about universal jurisdiction. The second thing that I just wanted to tell you fast, I was present in our Attorney General office while the Army came to ask permission to do such act or different. There were times that we, the legal team, against the Army team, were shouting and fighting, because in our head, as legal team, we thought that something that the Army had requested was forbidden. And the officers of the Army told us, not once, you want us to protect your people, like Israeli people. You want us to see that there will not be terror. You close our heads. And if things will happen, don't come and blame us. This is a very, very delicate situation, but I can testify, and it was then, and I'm sure that it's today, that the thing that were always like a light was us was international law. And the Supreme Court, sitting as the High Court of Justice, gave a few decisions that the Army was very much against. They said, well, they're sitting in the mountains of this thing, and we are having to be down. But this is always a balance that we have to take care of. I just wanted to come and to tell you those things, because when I see that Israeli soldiers are being submitted to universal jurisdiction in different places, while Israel is doing what she can, and while terrible atrocities, rape, I don't know what, happening in all kinds of the world, and people are just walking in the world, I'm asking myself, is it hypocrisy? What is it? Thank you.
On the issue of complementarity, I think it's fascinating to hear Yurit's talk, especially in light of what the Ron Almog said in the earlier session, that before Israeli military operations occur, there's multiple layers of legal oversight at the level of the command, at the level of the chief of staff, and at the level of the legal advisor of the government. So if you have that kind of legal input, and if you have actual Israeli legal actions taken against soldiers who have violated international law or laws of war, then applying universal jurisdiction to Israeli officers seems disproportionate use of force. I'd like to turn to Professor Eugene Kondratowicz, who of course has been involved in this event all day from Northwestern University, and he has also an added expertise on the issue of piracy and universal jurisdiction.
Turn that off, actually.
No, don't turn it on. There's some other reason that he has in mind. I defer to the technical.
So I'd like to thank the Global Law Forum, Jerusalem Center for Public Affairs, for putting together this wonderful event. It's a wonderful new organization, and looking forward to their increasing role in discussing these issues. So it's a very good time to be addressing universal jurisdiction in a public forum, because it has become a very public issue. Because the classic universal jurisdiction offense, piracy, has now become a very important, newsworthy issue. It's on CNN and BBC all the time, and it's very much in the public eye, and allows us to learn and look at the practice of universal jurisdiction in a new and improved way. So the current upsurge of piracy off of the Horn of Africa comes at a time when we have heard bold and strong statements about the new era of international law, an era marked by the increasing robustness and reach of international criminal law, and as we have been discussing, by the broader use of universal jurisdiction. And the claim made for universal jurisdiction by advocates of its broader use is that it will end impunity and usher in a new era in international law, that people will not be afraid of committing these kind of crimes anymore, and the world will be a better place. So piracy is the original source of universal jurisdiction. Piracy has been a universal jurisdiction crime, and it was the only universal jurisdictional crime for 400 years. It's the safest thing that you could have universal jurisdiction for. unlike many things like the precise definition of war crimes, the precise definition of genocide. Everybody agrees that piracy is universally recognizable. Everybody has always agreed, and there's a complete definition as to what it means. And it has the added advantage for the use of universal jurisdiction that there are no politics involved. Why are there no politics involved? Because pirates are not governmental actors. Universal jurisdiction, which involves war crimes, genocide, torture, almost always involves action by governmental or quasi-governmental actors. Pirates, they're just guys on their own. They're not endorsed by their home country. They're well-armed fishermen, let's say, right? And they are generally not, they're certainly not in the armed forces of any country. They are not protected by any country, generally speaking. And certainly, they are not involved in international armed conflict or in internal civil wars, which means the use of universal jurisdiction over them is not going to offend anyone or lead to the kind of problems we have been discussing. So if you think that, so it seems like a safe case, also, okay, a safe case. So let me say a few words about the current piracy problem. It is not a new problem. Piracy has been going on off of the Horn of Africa probably forever, but in an important way, certainly for the last decade, off of the Gulf of Aden, with the collapse of the Somali government in the 90s, there has not been any kind of domestic law enforcement, and the collapse of the government has allowed anyone with a fishing boat and an RPG, which turns out to be a lot of people, to go and seize commercial vessels. This is a really wonderful crime from the point of view of crimes, of criminals, because it's very easy to do. So today, commercial vessels move extremely slowly. They're large, they're not designed for speed, they're designed for maximum cargo capacity, and they can always be overwhelmed by speedboats. So in shallow waters, they're caught up with, there are very few crew on board. The crew is not particularly interested in the cargo, the crew just wants to get home. So really, no one is going to resist these pirates. They climb on board, they take the ship hostage, they ask for a fraction of the value of the vessel from its owners. It's really in everyone's interest. A deal is struck, and it's almost impossible to resist. So in recent years, the problem has grown steadily. The incidence of this has grown steadily. And there has been repeated calls over the years, not just this year, it's actually a long-standing problem, to have some kind of international response. The reaction has been slow, but there has been some international reaction. So, NATO has sent a task force from 6 countries to the region. A few other countries have vessels in the region. And this summer, the United Nations Security Council passed a resolution authorizing pirate vessels to actually be pursued into the territorial waters of Somalia, a resolution which had the support of the Somali government, which is not particularly interested in protecting these guys. So there has been some response. At the same time, which you would think would lay really the perfect groundwork for the exercise of universal jurisdiction. You have some ships, you have this nice Security Council resolution. So what has been the payoff? This year, the piracy problem, the seizures of vessels, has increased threefold over last year, despite these measures, including the most dramatic and spectacular seizures we've yet seen, a Ukrainian vessel carrying battle tanks bound for Kenya, another vessel carrying crude oil straight from Saudi Arabia, which caused the price of oil to jump $1 a barrel, which is quite a lot just from that one seizure, and many other important seizures. How many universal jurisdiction prosecutions have there been? In the whole period going back, let's say, since the end of the Cold War, I can count 1. And I can tell you more details about that. It was not a very important one. And certainly since these new international measures have been imposed, there have been no international jurisdiction, no universal jurisdiction tribunals. So the impotence of the so-called world community in the face of primitive banditry that challenges the most basic norms of the international legal system, the safe transit of international waterways, the freedom of the oceans, really the basic essentials of having an international community, international commerce, the ability of really a small group of completely primitive and disorganized highwaymen to harass international shipping with no effective international legal response shows that today international law and universal jurisdiction, for all its lofty goals, for all its great prestige that it is afforded, has in many ways become irrelevant to some of the more practical problems of enforcing the international legal order, and we should consider why that has become the case and maybe what its implications are. So people have been discussing, if you read in the papers, so there should be an international legal solution to piracy. Right? It's an international problem. The problem of piracy off the Horn of Africa.
Professor Adolf, who heads the Global Law Forum, to conclude our conference and with related to some of the issues that have just been raised.
Thank you. I know you must have been wondering what this was all about when you saw it earlier. So I'm going to begin here with the Nirvana Policy. I don't know how many of you have ever heard of the Nirvana Fallacy. It's a term invented by Harold Demsitz, to the best of my knowledge. He's an American economist. And it describes a certain kind of argumentation in public policy. The assumption is that there is a perfect public policy out there, and all we have to do is identify it. And the way to identify it is to find the flaws in its opponent. So we assume there are two policies out there. One of the policies, A and B, is perfect. We find the flaw in A, and therefore B is the correct policy, because by process of elimination, it is the perfect policy. Now, that's the way policies about universal jurisdiction tended to be argued about. We have two possibilities out there. Possibility A, universal jurisdiction. Possibility B, no universal jurisdiction. If we have no universal jurisdiction, there will be nasty, awful criminals out there that will get away with it. They will have impunity, and genocidaires will walk around the earth. Therefore, since that policy is flawed, the remaining policy, universal jurisdiction, is perfect, and it is the correct policy. Now, I want to highlight this the other way. What are the flaws that we have with a policy of universal jurisdiction? Now, I don't myself want to fall into the Nirvana fallacy, so I'm not going to argue that simply because I've identified the flaws that the policy of no universal jurisdiction is thereby automatically the perfect policy. I simply want to identify this, and then we're going to have to ask ourselves, of these two worlds, which one's better? Or perhaps there's a third way altogether. Okay. Now, here are three flaws that I want to highlight with universal jurisdiction. I want to talk about the way it works in the following ways. There's jurisdiction. It's a very interesting thing. Universal jurisdiction basically says any judge in any court, anywhere in the world, may entertain and prosecute a case, which we're talking here about universal criminal jurisdiction, where the accused is accused of certain heinous crimes. And the heinous crimes we're talking about are generally genocide, war crimes, crimes against humanity, torture. That's the general list. Okay, now, so let's focus on each of these elements. First of all, the judge. This is any judge in any court anywhere in the world. Now, I don't know how many of you have ever appeared in court or been forced to appear in court. But I'm sure that if you have, you've discovered that most judges in the world are terrific. They really are. But every once in a while, there's one who's a little bit less terrific. And I'm sure if we surveyed all the courtrooms in all of the world and all of the judges, we'd find one or two that are a little bit less than terrific. Now, universal jurisdiction doesn't give the authority only to the terrific judges. It gives it to all of the judges, including the not terrific judges. Okay? And so this is one element we have to pay attention to. I'm going to go back to that in a moment. Number two, universal jurisdiction exists according to the accusation, not the crime, the accusation. If I accuse X of genocide, then X may be brought up in trial in any courtroom by any judge anywhere in the world. Whether the crime ever happened at all is not relevant to the question of whether of your universal jurisdiction. The question is just simply what has been alleged. Now, there's an obvious response to this, which is people make inflated allegations. Right? And if you make an inflated enough allegation, you will have your day in court. Number three is all these things, genocide, crimes against humanity, war crimes, torture, these sound and are awful. The problem is the law of them is also awful. It is awful in the sense that it is very, very difficult to disentangle. You think you know what genocide means, but you probably actually don't know what it means in the legal sense. And I guarantee you don't know what crimes against humanity means in the legal sense. All right, so let's go to talk about each of these very briefly. One judge. All right? I said any judge anywhere in the world. Well, I don't know how many of you know this, but most of the law that we have of universal jurisdiction is the product of one judge. It's one judge in Spain who has been in and out of politics. Baltasar Garzon, you'll have to excuse me if this has been mispronounced. Here's some of the people that he's had in his sights for bringing into his courtroom. Now, he hasn't been successful with all of them. Right? Pinochet kicked off the whole Pinochet affair by issuing a warrant. He's issued a warrant for Osama bin Laden. He hasn't yet been brought to court. He wanted to bring before his court Henry Kissinger. That didn't happen either. Berlusconi, he didn't get either. Some of these others he managed to. Francisco Franco, unfortunately, is dead. And so he couldn't get him in front of his courtroom, although that didn't stop the judge from beginning, at least, proceedings. Right now, accusations. Let's talk a little bit about accusation inflation. Right? Here is a wonderful document from the Organization of the Islamic Conference accusing Israel of the war crime of permitting an aggression against the ascent to heaven of Prophet Muhammad, peace be upon him, by permitting a private person to purchase a synagogue, clean it, and open it for prayers. Right? Why? Because the synagogue is in the old city of Jerusalem, close to, but not on, the Temple Mount. And it is therefore insulting to have a synagogue so close to the Temple Mount where the Al-Aqsa Mosque is. And therefore, it is a war crime. Now, I have a little bit of a difficult time identifying where precisely is the war crime here. But, here's another one. Iraq veteran Jimmy Massey speaks to the World Socialist website. We're committing genocide in Iraq. Right? Let's get beyond war crimes. Genocide. Clinton and Blair, guilty of genocide. Why? NATO acknowledged that one of its planes had mistakenly bombed a Kosovo and Albanian refugee convoy. Genocide. Here, this one's another one. Francis Boyle was a legal advisor to the Palestinian delegation, to the PLO delegation, to Middle East negotiations. Israel, he said, has committed war crimes, crimes against humanity, genocide, on the basis of there was an October 2000 resolution of the UN Human Rights Commission that was voted in favor of by the following countries: Bangladesh, Bhutan, China, Cuba, etc., voted against by Canada, France, Germany, Italy, Japan, etc. This resolution adopted by the vote of 1916 made several strong and conclusory statements on the basis of nothing, accusing Israel of war crimes, crimes against humanity, and implying but not stating outright genocide. And that, of course, obviously shows us that war crimes, crimes against humanity, and genocide have occurred, and therefore any soldier participating in the Israeli army in any way has committed these war crimes, crimes against humanity, and genocide. Now I want to talk just a moment about the
questions that were raised, but we're going to have to bring the session to closure pretty soon. There's a question for Irit Khan. You claim that the use of universal jurisdiction against Israelis has been highly politicized and counterproductive. Is this generally true of universal jurisdiction? And if noting how these politicized cases, anyway, how should these politicized cases be handled? Another question for Professor Gregory Gordon. I've heard that the British government has given orders not to arrest and try pilots under universal jurisdiction for fear that they will use the opportunity to request and receive asylum. Is it possible that we should look at the prosecutions of Rwandan murderers in places like Canada as nothing more than a reward as a reward of safe haven? And there's a last question for you, for Professor Kantorovich. If Professor Kantorovich is right, that universal jurisdiction does not deter criminals, what can be done to end their impunity? So I'll ask each one to answer this, and with that we conclude our event. Great.
My lecture was at the beginning, I was showing that I think that universal jurisdiction is not a solution at the way that it's performed. So this was my idea. It's not only against Israelis. I say that the universal jurisdiction, the way it is today, is very political and we can't use it. And then I went to show how it really hurts Israel and what is the way that it's done. So I hope that I answered this question because otherwise I wouldn't understand it. Did I answer the question?
I think the question to me is one that relates to international criminal law in general, because it's often argued that defendants who are going to be put in prison in cushy places such as Europe or Canada, places like that, then these are the high-ranking, these are the high-level perpetrators of atrocities, that it's not fair that that's their lot in life when they've committed arguably worse crimes than the foot soldiers who find themselves in national jurisdictions where they're put in horrible prisons and endure terrible conditions after they've been convicted. So I understand that that's an issue, and I think it's a complex question to a certain extent, because you have to balance the, I think, utility of trying high-level perpetrators in an international forum and what the good that does on many levels versus the amount of punishment that the person will receive. And it's a tough question, but I think it's there all the time.
So I was asked, if not universal jurisdiction, what could be done to end the impunity of violators of international human rights, committers of gross atrocities? It's a very lawyerly question, one which I always get when I speak to groups of lawyers or law students, because the assumption is that if there's a problem, there must be a legal solution. Right? Your neighbor is bothering you, go to court. But the law has generally not been a solution for all the problems of mankind, particularly the most important problems. There's no particular reason to think it would be here. If one wants a start to ending impunity, prevent the offenses before they occur. So intervention in Rwanda, intervention in Sudan, that's a great way to end impunity, because you have to arrest the person first. That's usually the hardest part, actually. But the lack of any kind of willingness or interest to do that on any kind of significant scale. I'm not even mentioning intervening in China and Tibet, to take a more salient example of human rights abuses. The fact that that's completely unrealistic and people would say that's crazy suggests that there really is not an actual interest in ending impunity, only ending some people's impunity some of the time.
I want to thank everyone for attending today. It's been a very important conference, great location, and tied in with actual substance of what we've been discussing. And this will be on the Jerusalem Center website. Of course, we'll share it with our partners at the Henry Jackson Society. So thank you again.
Thanks for that.
Anything Yes, I think it'll be on the website.
That gentleman as well.
You should ask him for it.
Thank you. Thank you so
What's
much.
Tree Alpha International?
My investment bank is very
Lines against humanity.
I'll be the for living the brothers. Brent.
Wonderful.